Our office is the only people out here that don't. I know people in the South County that don't think it's even worth 500. They think it's worth more.
Okay.
So
So then you mentioned a deadline. So if somebody, you get assessed, you're not happy with it, does this deadline come around just annually?
yes, 29th of November.
29th.
So I'm pretty sure this year with the postmark and all that, it can be postmarked by Monday the 1st. I don't know. Check me if I'm wrong on that, the deadline.
So just
Sound
say,
right? We're not sure about the deadline. It's the 29th of November is the deadline, but there's a postmark thing, whatever. So basically this week.
so say if somebody buys something and they feel like they've been wrongly assessed, and they get the supplemental assessment, say, the 3rd of December, so then do they have to wait like a whole year to?
Well, if they were to get it on the 3rd of December, yes.
So they-
Typically the supplementals, if they're toward the end of the year, are going to go out with the regular tax bills probably the end of October. So you have, at least a month to file on a supplemental or a base year value from the previous year. So yeah, if for some reason, which I don't think they even send out supplementals December 3rd, but if they were, then yes, you would have to wait till the deadline.
So if you buy something, say in January, then when would you get notified? Say you bought it for, $1,000, but you thought it was worth,
If it was appraised, let's say September, in our office, you'd probably know about the value within a few weeks, and you'd clearly have until the deadline to file an appeal.
So if you bought something, let's just say in November, okay, and you bought it for, $1,000, and you guys thought it was worth $50,000.
Right, if you bought it in November, we probably wouldn't look at it until springtime
So then you have to wait till the November.
to file an appeal, but that, goes back to when you bought it, and you're perfectly within your rights to challenge your base year value that the assessor puts on there, yes.
Can I ask you a question? Yeah. Okay, so the deadline is November 29th, so they could file an appeal anytime prior to it, so you have 364 days prior
Absolutely.
to November 29th.
Absolutely,
In order to deal with
and
that particular tax year, so
Sure.
if all the sales take place in December and the assessment happens in February and the notice goes to them in March, they could file the appeal in April. They don't have to wait till November 29th.
oh,
They
no,
can
not
do it
at
in
all,
April,
not at all.
and
I didn't mean to imply that. I'm sorry.
Once the appeal is filed, how long after that does a hearing take place? Do they have to wait until they're bunched up after the November 29th, or can
No,
they be held prior to
the
that?
way it is now is we're scheduling them as they come
Okay,
up,
well,
and we've
That's
scheduled,
the way we
the
usually
ones
do
in
it.
January will be the 5th and 6th in the last probably 18 months. I don't know, Stephanie, does that sound right?
I'm not sure how long it's going to last. I can tell you that we did have 2 days in October of hearings that we just had, and all of the current assessment appeals all the assessment appeals that have been filed are scheduled to take place in January.
The November 29th deals with that particular tax year. Okay,
Right.
once that date, then you have to deal with the next tax year, and you have until November.
Yeah, I might have misunderstood your question.
Yeah.
You can certainly file in December and it'll be done.
Okay.
But it
Yeah,
has to be
I think
before
we-
that for the previous year. For the previous.
So-
We don't want to wait a year to.
So why would it take 2 years if you're unsatisfied to get your?
2 years is the maximum, and it's perfect.
But I was told, because I went through this too.
Right.
But I was told it would take 2 years. Why would it take 2 years?
I don't think it has been taking 2 years in recent times, to be honest with you.
Why would it take
2
2
years.
years on anything?
I can't answer that. One of the reasons is
Who's best to answer that? Because I think it's a valid question. It needs a.
well, okay. So we're talking about the past now. I'm saying that in the last 18 months,
We're talking about the very recent past. I think just up until recently, the language.
up until the last 18 months. So, in the last 18 months or so, between the new county council and Julie and myself and Mr. Bunch, who just retired, we've gone to great lengths to get this stuff scheduled and taken care of, because 2 years, in our mind, is ridiculous. We agree with that. And there's no particular reason it was like that, but we've taken steps to make that not happen anymore. So we are trying to remedy it. And we're not saying that that was right wrong or otherwise, we're trying to fix it.
That was
That's
the
where we
common-
stand right now.
That was the common language, the 2 years. That's what
That it's gonna take 2 years, I don't,
Mr. Chairman, I think, correct me if I'm wrong, Dan, I think there's a requirement in the code that if it's not held within 2 years, then the appellant is deemed to have won the
that's
case.
absolutely
Correct.
So what's the practice to wait for 1 year, 9 months, 1 year, 10 months to hear these appeals?
Julie wants.
I would like to speak to this since it does affect our office, and I did spell this all out for you. Sorry I'm late.
Can you state your name?
My name is Julie Bustamante. I'm the Lassen County Clerk Recorder, and also the Clerk of the Board of Supervisors who does the assessment appeals. Sorry I'm late. Your meeting is not being broadcast, so everybody thinks you're still in closed session.
Well, it's on.
We'll talk to the circuit board about that.
There's some funny stuff going on.
That would be IT.
Yeah.
I prepared a small packet for you.
Richard
There's
plugged in his unit to that thing over there for a while, and it shorted out.
That's-
Everything else could be.
Okay, that's new. Well, thank you for having me. Like I said, I'm short-staffed right now. I've got one person holding down the office, so it's difficult to even be here, but I made an effort. I prepared a spreadsheet that shows how many assessment appeal hearings have been held over the past 4 years. And we have had 7 hearings over the last 4 years. The statement that it takes 2 years is inaccurate. We have to have scheduling coordinated with at least 3 departments. One of them being county council, the assessor, and the tax collector's office. Yeah, that's extra. Not to mention having to have a board available who can hear these hearings, which isn't always easy. It's hard to keep people on the board that qualify. And we've had that come to the board too. I've been short-staffed. I've lost 3 people out of 6 in the last couple of years. That's half of my staff. I have to run 4 separate divisions. 2 of them left during a very critical time during elections. That's 33% of my staff during a year that I have 2 major statewide elections. That hasn't been easy. Not to mention the turnover that the county's had in the administration department. We've had different county councils. We've had different CAOs. It's been difficult to coordinate anything, but I think having 7 hearings in 4 years is pretty darn good. We had 147 applications filed, and I've got this in your packet. Of those, 132 were withdrawn once we scheduled the hearing. Scheduling the hearing isn't just setting a date. It's mailing registered letters to all 147 people that have an application in there. Of those 147, 97 have actually gone to hearings. Of those 97, 5 people withdrew. This is after the hearing scheduled, after all the notices are sent, after everybody's on board to be there. 5 of those applications were withdrawn by the applicant. 10 of those applications, the applicant didn't even show. They didn't even bother to come to the meeting. 21 of them requested extensions, and if they asked for an extension, we grant that because that's in the property tax rules. 48 stipulated before the hearing. A stipulation is when they come to an agreement with the assessor before the hearing's even held. But we still have to hold the hearing. We still have to bring them in there, and the board still has to approve those stipulations. 13 of those 97 applications actually were heard by the board. And this is through no fault of ours. This is the applicant's doing. I've got a list of all the applicants that are pending right now. We have 39 pending, and we have had 2 hearings this year. We have 2 more scheduled for January, and they will all be cleaned up. Every single one of them will be taken care of. And we hope to stay on board and keep them caught up now that I have staff aboard and we're training. And we have a county council who has jumped in and been a tremendous help and helped us get these going, because it can't be done with just one department. We also have a new assessor. He's working with us diligently. We are trying to get these things settled before they even have to go to hearing. One of the problems I have is the budget. The Board of Supervisors has only budgeted $1,200 in the assessment appeals. This year alone, because of the 2 hearings, we've already spent over $2,176. Or that's what we expect to be in the hole by the time the January meeting is finished.
How much was that again, Julie?
We have $1,200 in the budget, and that's in your paperwork too.
Okay.
The budget line item, and how much we've spent so far, and what we
Who
anticipate.
requested the $1,200? I mean, you make it sound like it's the board has determined
It
that.
comes
and-
from admin.
Well, I'm just saying is, it's, what's in there is because that's what was requested, so.
Not by me.
You're telling me.
That's what's
that
been
you
in there
did-
over the years.
Okay.
I mean, it's kind of a fine point, but the clerk didn't get the budget request in timely, so the administration prepared the budget request. Is that your question?
No, that
And
wasn't part of my budget. This is in the
My
board's
question is, who
budget.
determined the $1,200?
Yeah.
The board approved it, they ratified it, but the board didn't make it up. It was presented to the board, says, this is what we need. Now we're being told this is not enough, and it's the board's fault. But it's not the board's fault, because the board has only been asked for $1,200. Now, if we need to put $5,000 in there, then tell us and let us amend the budget and put
Well,
$5,000
that's because the
in
board didn't know we were going to have all these hearings.
My recommendation is based on past history and what has happened in 14-15 fiscal years with new county council and staff. They've done all these hearings, and that's why the cost. In previous years, the hearings haven't been going on, so the cost hasn't been there, and the request was not made. So,
And it's not under my budget, it's under the board's budget. So it's not my responsibility to do. I can do it. I can check
It's
into
under
it.
the non-departmental budget.
Right.
And that's
But-
usually-
But the
do you-
fact is,
as a reason to
We
not
need to do it.
hold hearings, that's not adequate. It's well within my authority to allocate additional funds for the hearings, and it's so
and
presented
that's
with
not
the
what I'm
request.
saying. I'm not saying that's the reason we didn't hold hearings.
And if I'm presented with that situation, I'll make sure the funds are available.
The budget shouldn't be a factor.
It's not.
No, but I'm catching you up on everything, so you need to know where we're at
You know,
with it.
I appreciate.
I don't want to
you-
come back later and be surprised I need more money.
Well, I appreciate you letting us go because I don't like being surprised either. So if we're going to need $10,000, then let's put 10,000 in there. I mean, if you have to budget what it takes to get the job done.
The budget's not a factor.
No.
Right.
What I'd like to interject and say is that when the clerk is discussing hearings, and there's only 7 hearings, she's talking about full days of hearings. So that's just not an individual hearing as far as one person being heard. On any given full day, we can hear quite a few.
We heard 40
cases.
in October 17th.
How long
So I
did
just
the,
wanted to
how long
clarify
did the
that.
hearing last?
That one lasted all day. The one on October 30th, they only had 5. Some of the applicants didn't show again, so that only lasted half a day. But we still have to do the findings, we still have to do the minutes, we still have to send out the registered notices, we
Right.
still have to do all that.
And there's a lot of prep work that goes into not just council, but also in the assessor's office in preparing their case, because the burden of proof shifts depending on what kind of building we're talking about. So the assessor has to prepare a case, and if an applicant doesn't appear, the assessor's office has done all of that groundwork and that background to be able to prove their case, and if the applicant doesn't show, that's still quite a bit of work for their office to have done.
Another suggestion I'd like to bring up is having an application fee. Most counties in California charge an application fee. If the applicant is successful, they end up getting that fee back. And I've put in a spreadsheet that shows what all the 30, I think there's 32 counties that actually do it, are charging. It could be anywhere from $17 to $200, depending on the county. But if we did this, we wouldn't have 147 applicants with 32 walking away. Hopefully that would deter frivolous applications. And so I'd like to suggest that to the board also. I know you can't make a decision today, this is just hearing information, but I can bring that back. But
I
I wanted
think we
to
all want to
remind you.
straighten this out to the better.
And it is
of our
being straightened out,
constituents.
yes.
I think this is a real good start.
Well, you have to consider staff shortages too.
Yeah.
We have half of our staff being gone, and you have to get things done. We had to do the election, didn't have a choice.
Yeah.
And the election doesn't just happen election day. It takes months and months of preparation, planning, and putting it together.
For the board's benefit, at the state conference last week, the County Clerks Association of the state also had their annual conference in conjunction, so did the engineers and a few of the other groups. And the Clerks Association had one whole half a day of basically a workshop or training or meeting in which they dealt with the assessment appeals process. So this issue that we're having discussed here is these conversations are happening all over the state, so there's a fair amount of either it's not working or it's working too well or whatever. And so other counties are trying to figure it out as well.
You
I
know,
almost went to that now after listening to this discussion. I kind of wish I had.
I think that, you know, the public, if somebody was able to go in and feel like they've been, you know, wrongly assessed, and go in and get an application, I think people would be happy to pay a fee. You know, you said it's from $17 to $200, $100, you know, application. Yeah, so say it was $100 or whatever fee, and have a list of directions, and know within 6 months maximum they're going to get their day at the appeals board. I think people will be happy with that.
The law
I
states
just think
that
when
it
it's
has to
open,
be held
you know.
once a year, every July. And I put a copy of the Revenue and Taxation Code in there, and that refers to the third Monday of every July is when a hearing is supposed to be held, or as soon after as you can get it done.
Yeah, so what happens if somebody contests their assessment and they refuse to pay their bill until their hearing? What happens then?
I don't know about tax collection.
Well, that's a tax collector issue. No, I'm not passing the buck, I'm just saying.
They have to pay the bill.
So you have to pay the bill
Or
Get
their
penalties.
assessed penalties.
So that's what happened with Iron Mountain.
That is one of the things that happened with Iron Mountain. They did not pay their bill, they filed, I think, one appeal out of 4 or 5 years.
So you have to put the money up, and if you don't pay it, you're charged interest or
Yes.
a penalty.
So, but I mean, is it possible to come up with a system like that where they could know within 6 months you're gonna have their appeal? I mean, I know you mentioned that it shows only need to do it in July 29th.
If I have the staff, and we can get it coordinated with the other departments, yes.
But
And that's what we've been
yeah.
doing.
Don't you agree, Rid? Would you agree? I mean, don't you think that that's what we should strive for? Like 6
I
months.
think that's
to hear your deal.
a reasonable time frame, but I think there may be some appellants that are actually hoping that it goes the distance, because if it goes 2 years in one day, they win. If the county doesn't get around to it,
But I mean, we don't want to really. But it's not that.
then I think a few of those have occurred, right?
We just mailed out 32 registered letters this week. I had a phone call this morning from someone saying, but wait a minute, I extended that. I don't want to have a hearing yet.
But like you said, it's
That's-
no charge, so people could, monkey around. Why don't we, I mean, this is something that,
Needs to be fixed.
yeah.
It is fixed. We are fixing it. It is better. We're almost caught up. We almost have all of them off the record.
Yeah, but I think when it's truly fixed is when the people pay a fee, so you're gonna get the people not coming in there wasting your time, offering extensions, because it didn't cost them anything.
Yes.
So I think when it's truly fixed is when they have an application, they pay a fee, there's the parameters on time, and I think it's improved now, but I don't think it's fixed until we get to that.
I agree.
So, I mean, would the board be interested in trying to come up with maybe a process that we could agenda?
If I could just make one comment on that. The board, I think, has the authority to impose a fee, and that's probably a good idea to bring back. But I do think there's an issue here with, you've got 2 elected officials, independent of the board of supervisors, who are performing this function. I think the board can't necessarily impose upon them restrictions that are are more restrictive than the government code. The code says they have up to 2 years, and they've indicated they're going to try to reduce that, but I don't think the board, council may correct me, I don't think the board has authority to impose other restrictions on them.
Maybe not, but I think it's good while everybody's here, the media's here. I mean, if they want to tell us to go jump in the lake, we got 2 years, well, then fine, but let's hear it,
Well,
instead of us getting, people calling us and saying, why does it take 2 years? So, I think it should take 6 months. I think there should be a fee. That's what I think, and that's what I want to say publicly. If the elected officials say, well, no, that's not what I agree with, then fine, but let's let that be said, because I don't want the public to think it's me making the rules, or Hammond, or Pyle, or Chapman. That's my recommendation, and it's great that the elected officials are here. So if the elected officials agree with that recommendation, then let's move forward and try and get it resolved.
First of all, Mr. Chairman, if I can jump in on that question, I don't think it's appropriate for the board to be ordering elected department heads one way or the other. But at the same time, the elected department heads are dependent upon the board to provide budgets and resources. And so if we have kind of a Mexican standoff where they want to do it their way, and we want to do it our way, and we can't come to an agreement, and you're going to have a test of wills. And I've seen that happen in years past, and that doesn't provide any productive output. And so we have to avoid that. But at the same time, I don't like listening to statements being made, because of staffing or because of budgeting or whatever. I don't think those should be issues that should even intervene with this particular process. And I think it's appropriate to come up and say, hey, look, I don't have enough budget and I don't have enough staff. I get that, okay? So
I hired Teresa Nagel to do the last 2 hearings.
Okay.
Because we couldn't. And that's where the extra cost came in.
okay, I have no problem with that. But I would say that what the response to that is that if that's going to become a barrier to the process working, then it's not going to be the board's going to be ordering you to do this or do that, trying to jerry-rig the system. The board needs to direct the county administrator, who's the one that oversees the personnel operations, oversees the budget operations, and so forth, is to come back with a plan of how he's going to augment the resources that exist in those departments. He can do it 2 ways. He could add staffing, and he could add funding, or he could set up staffing or funding in a third-party setting somewhere within, we got 430 employees in the county. So if it's clerical staffing, if it's whatever it is, maybe by rearranging and temporarily assigning this person or that person to focus on that, because we don't need to staff it for 365 days, because if you're only going to have hearings, 3 or 4 times, I mean, you got some preparatory things, but it's not something that one person is going to be doing that as their full-time focus. It's going to be a shared responsibility. And I think that's where the CAO has the responsibility to come back to the board to see how that's going to be augmented and operated. And you may like what he comes back, and you may not like it, but if the board directs it, that's how we're going to approach dealing with it, you've got to make it work within that. I mean, so we're not telling you how to do your job, but if you need the resources, you're going to have to respect the allocations and the direction it's coming. And I think we have to do this in a shared fashion before we even deal with engaging the public, who are the ones that this is supposed to be all about anyway, in terms of benefiting their particular interests. But to have a process that doesn't work, that isn't staffed, that the budget's not right for it, it doesn't accomplish what the law requires to be done. And, and I think it's, Mr. Chairman, I think it needs to be the reaction. Because I've seen in the past where we've had, there was one time, we had an assessor. This is many years ago, long before Dan came along, and he just loved fighting with the supervisor from Westwood, and they just had this personal animosity. And he liked me because I was new and I was a kid, so he'd use me to tweak the other guy. But he'd literally come to the door, and he'd make his presentation, and he'd leave, and he'd get to the door, and he'd open, and he'd get halfway out the door, he'd turn around, lob a couple bombs back at that board member, and all hell would break loose, and that was, but the public's not served.
And I hope you don't think we're here saying, no, we're not going to do it, because that's not coming out of my mouth.
Right.
We're working on it. We're doing the best we can with what we have.
I think November 29th is a magic date, but I think that if somebody gets a supplemental notice and if they file an appeal, I think we should work to try to get that into some sort of a process that's resolved long before it ever gets to November 29th.
I agree 100%.
And I think we're getting there.
Well, that's good. That's
Well,
good.
and with regard to the resource issue, county council and Stephanie have taken a leadership role in getting the departments together, getting these things done, and so now we're looking at a 3-month turnaround rather than whatever the date is.
And that's been a tremendous help.
And I think that's working.
So if you do that, you're not going to run into big elections and other things that distract you. If you can break it down and do it small bite-sized pieces rather than having one big onerous chore at the end of
Which
the
is
day.
what we're doing.
So whose responsibility would it be then to come up with the content of the application, the fee? Is that the board, or would that be Julie or Dan?
The application is state. The state creates the applications.
But you want,
But
It has to be approved by the board.
okay, so like the fee, who would?
Well, I think the board would have to set it openly, but I think we would have to react to a recommendation from the county administrator. It needs to be.
And it would have to be supported by actual cost, I believe.
Yeah.
It's not an arbitrary,
Yes.
it'd be a tax, but just an arbitrary.
Was that something that the board's interested in moving
Oh,
forward this, in the next meeting or two?
Yes.
I certainly would like
Yes.
to be a part of
The
it.
idea being that if an applicant is successful, he covers those fees, come back to us. We want the applicant
Loser pays.
to lose their fees.
And,
That's a very
you know, just with some sort of guidance, just so people know it's not going to take 2 years. Look, we strive to get it done in 6 months, but with no, you know, there's no guarantee. You know, at least you know, instead of just being told this can take up to 2 years.
Well, I will say that the current California law is the maximum of 2 years, and all of our hearings are taking place within that time frame. What I'm, of course, hearing is that that's not fast enough for the people here and the members of the board. What I'm hearing is that's not fast enough, and so we have sped up that process. Like I said, everything that has been filed is scheduled to be heard in January.
It's just that if you get a bill that you're not, you think, you know, is unfair, and it's like not a $10,000 bill, you're assessed like $300,000 or $400,000 over what you think. It's not a good feeling to know you got to pay a couple of tax bill cycles before you get your day.
No, I absolutely understand that, and that's why so many, we've got several departments that have come together and worked on speeding up this process and putting these new practices in place.
So let me ask this question along that line. So if somebody gets a tax bill and they feel it's unfair and they file an appeal, and so they don't pay the tax bill, and now there's penalties and interest, but when the hearing is actually held and it's determined that they were right and the system was wrong, and an adjustment is made, okay, do they still have to pay the penalties and interest, or does that become?
That was what I was asking earlier.
Yeah, I mean, I think you did ask that question. I never heard an answer to that because, I mean, it's a gamble because if you wind up losing the appeal, you're going to be on the hook for not only the tax but also the penalty and interest. But why should somebody who appeals, who feels they've been unjustly wrong, wind up having, after they win the argument, be put in a position where they have, you know, their property may be going up for tax sale because they didn't pay the interest and the penalty on a bill that was overcharged?
I'm not sure about the funding of it. I can say that the hearing actually changes when you have been assessed a penalty. The hearing is done slightly different to address that penalty.
Can that be researched and reported back to us what the law allows to happen so we can clearly communicate that to our constituents?
Absolutely.
Because I think we need to know that.
So you're asking, if you win the case, do you get your penalties and interest that you paid back to?
Right.
Well, I mean, obviously, the penalties and interest are generated when you don't pay the bill
Sure.
back on December 10th.
Sure.
And you don't get your hearing until April, and you get a decision maybe in June that you were overcharged tenfold. So you were willing to maybe pay $1,000, but not, you know, $10,000, and now you've got penalties and interest of another $3,000. So, you know, the tax collector is trying to get $13,000 out of you, and you wound up winning for $1,000. So,
But if I could address that just a little bit, I'm not exactly sure about the proration issue, but it's never the case where there's 100% winner or 100% loser. There's always, the Assessment Appeals Board always, I believe, comes back with some value. So there is some proportion of the penalties that accrue regardless of winning or losing.
well, so they come back and said that you should be assessed $2,000, not $10,000. But the fact that you have an unpaid bill.
We're talking on the margin in most cases. I mean, the one that brought up this morning is the extreme, but we're talking about on the margin of value in most of these cases. And so there is some penalty that that's assessed and, you know, will be collected regardless of winning or losing. and then there's the marginal amount that I believe is prorated back to the
Rich,
assessing.
can that be quantified in some sort of amount?
Correct me if I'm wrong, but this, when I did some research when I was closely tied to a similar situation,